Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or religious advice. Marriage and divorce laws are subject to specific state jurisdictions in the United States, and Islamic jurisprudence or fiqh is interpreted through various schools of thought and scholarly opinions. The complexities of matrimonial law and religious contracts require personalized consultation. Viewers are strongly advised to conduct their own due diligence and consult with qualified legal professionals and recognized religious authorities regarding their specific circumstances. For decades, there was a silent consensus within the American Muslim community that the institution of marriage was an unbreakable fortress, shielded by faith, culture, and shared immigrant struggle. But today, that fortress is showing deep, visible cracks. In many urban and suburban Muslim communities across the United States, divorce rates are no longer a whispered anomaly. They are reaching parity with the national American average, which historical trends suggest sits between 40 and 50%. We are witnessing a seismic cultural shift where the stigma of the divorcee is being dismantled by a generation that prioritizes mental health, individual rights, and legal protections over the preservation of a fractured image. This is not just a change in statistics. It is a fundamental transformation of how faith is practiced in the private sphere. We are entering an era where the double divorce, the simultaneous navigation of a U.S. civil court, and a religious Sharia council, has become a complex, high-stakes reality for thousands of families. This video is the first part of a deep-dive masterclass into the silent crisis and the evolving landscape of Islamic divorce in the United States. We are going to peel back the layers of why the old models of conflict resolution are failing, how the U.S. legal system is grappling with Islamic marriage contracts, and what this means for the future of the American Muslim family structure. To understand where we are today, we must first look at the historical baseline of the late 20th century. For the first wave of post-1965 Muslim immigrants, the preservation of marriage was often tied to survival. In a new country with limited social safety nets and a tiny minority population, the family unit was the primary source of economic and emotional security. In those decades, divorce was often viewed as a failure of faith or a surrender to Western influences. However, as the second and third generations have come of age, the context has changed entirely. The American Muslim identity is no longer defined solely by the immigrant experience. It is defined by a synthesis of Islamic principles and American values of autonomy and justice. This has led to a fascinating and sometimes volatile friction. We are seeing a move away from collectivist thinking, where the reputation of the extended family dictated personal choices, toward an individualist framework where the quality of the marital relationship is the ultimate metric of success. Consider the data emerging from community surveys and social services. Organizations focusing on domestic harmony have noted a massive spike in inquiries regarding khula, the process by which a woman can initiate a divorce in Islam. This indicates a significant shift in power dynamics. Historically, the talaq, or the husband's right to initiate divorce, was the dominant narrative. Today, the accessibility of education and financial independence for Muslim women in the USA has fundamentally altered the negotiation table. When a woman has the professional means to support herself and the legal literacy to navigate a state court, the traditional social pressures to endure an unhappy or abusive marriage lose their potency. We are seeing case studies where women are no longer waiting for a husband's permission to exit a failing union. They are utilizing both the U.S. civil system and seeking out progressive imams who recognize judicial divorce. This shift is creating a unique set of challenges that this video series will solve for you. If you are navigating this space today, you are likely facing a mountain of conflicting information. On one hand, you have the civil laws of your specific state, New York, Texas, California, each with their own rules on asset division and child custody. On the other hand, you have the religious expectations of your local masjid or family elders. The problem many face is the legal limbo. This is a state where a couple might be civilly divorced in the eyes of the U.S. government, but still considered married in the eyes of their religious community, or vice versa. This creates a paralysis that affects everything from the ability to remarry to the distribution of the mahr, or the mandatory Islamic dowry. The goal of this masterclass is to provide a comprehensive roadmap through this transition. We will bridge the gap between historical religious traditions and modern American legal realities. We will examine the mahr not just as a religious requirement, but as a contract that is increasingly being scrutinized by U.S. judges. Is an Islamic marriage contract enforceable in a civil court? How do states treat the division of assets when a religious contract specifies a different outcome? We will look at historical trends in case law to see how judges in different jurisdictions have ruled on these prenuptial agreements. Furthermore, we are going to dive deep into the sociological reasons behind these rising rates. It is not as simple as westernization. It is about the evolution of the third space, the mosques and community centers that are now being forced to hire professional counselors and legal consultants to handle the volume of marital disputes. The days of a local imam simply telling a couple to be patient are ending. There is a growing demand for professionalization in marital mediation. We will explore how these institutions are adapting, or in some cases failing to adapt, to the needs of a younger, more litigious and more rights-conscious congregation. By the end of this series, you will understand the intricate mechanics of how divorce functions in the American Muslim context. You will learn how to identify the red flags in a marriage contract before it is signed, the step-by-step reality of the civil divorce process, and how to navigate the religious hurdles without compromising your faith or your legal rights. We are tackling the tough questions: the role of domestic violence in fast-tracking religious divorce, the battle over child custody when religious education is a point of contention, and the financial implications of zakat and asset sharing during a split. This is about moving from a place of confusion and stigma to a place of clarity and empowerment. Whether you are a community leader, someone currently navigating a divorce, or simply a student of cultural shifts in America, this deep dive will provide the data-driven insights and historical context necessary to understand the new reality of the American Muslim family. We are going to look at real-world examples of how mediation works when it is done right, and the cautionary tales of what happens when the legal and religious aspects of a divorce are not aligned. This is part one of our journey into the complex, often misunderstood, and rapidly changing world of cultural shifts and divorce in Islam within the USA. We are moving beyond the surface-level discussions and getting into the heavy details that matter for your life and your community today. To understand the current state of divorce within the American Muslim community in 2026, we have to look at the fundamental transformation of the marriage contract itself. Imagine a young couple in Northern Virginia. Let's call them Sarah and Omar. Sarah is a 32-year-old software engineer and Omar is a 35-year-old project manager. They married 5 years ago with a traditional Islamic ceremony. In their nikah or marriage contract, they specified a mahr, a mandatory gift from the groom to the bride, of $50,000, half of which was paid up front and the other half deferred until death or divorce. At the time, it felt like a formality, a nod to tradition. But fast forward to 2026, and as they navigate a civil divorce in a Fairfax County court, that document is no longer just a religious symbol. It has become a central piece of legal evidence. This scenario highlights a massive shift in how these contracts are viewed. Historically, in the United States, civil courts were hesitant to touch religious contracts, fearing they would violate the Establishment Clause of the First Amendment. However, historical trends over the last decade show that courts are increasingly treating the nikah as a standard prenuptial or postnuptial agreement, provided it meets the state's criteria for a valid contract. For Sarah and Omar, this means the court must decide if that $50,000 mahr is an enforceable debt, or if it should be folded into the overall equitable distribution of their marital assets. This creates a high-stakes legal environment where the wording of a religious document signed in a mosque basement 5 years ago now dictates the financial future of both parties in a secular court of law. One of the most significant cultural shifts driving the rise in divorce rates is the changing economic profile of the American Muslim family. In 2026, we are seeing a record number of Muslim women entering high-earning professions, from medicine and law to the burgeoning tech sectors in Austin and Silicon Valley. This financial independence has fundamentally rewritten the social contract of marriage. Historically, the traditional model often placed the husband as the sole provider, which inherently created a power imbalance where the wife might feel economically trapped in an unhappy or dysfunctional union. Today, when both partners are bringing six-figure salaries to the table, the motivation for staying married shifts from survival and economic necessity to emotional fulfillment and mutual respect. When those elements are missing, the barrier to exit is significantly lower. Consider the data on educational attainment. American Muslim women now represent one of the most educated demographics in the United States. This level of education brings a higher degree of legal and social literacy. In our case study of Sarah, she isn't just relying on what her local imam says about her rights. She is researching case law, understanding the difference between a contested and uncontested divorce, and hiring attorneys who specialize in the intersection of Islamic law and Virginia state law. This is a far cry from the experiences of previous generations who might have felt they had no choice but to endure. The potential outcomes of this shift are twofold. On one hand, it leads to healthier, more equitable marriages based on genuine partnership. On the other hand, it leads to a higher frequency of divorce as individuals are less willing to compromise on their personal well-being or career aspirations for the sake of maintaining a traditional facade. Imagine another scenario involving a couple we will call Michael and Layla. Living in a suburb of Chicago, Michael converted to Islam before marrying Layla, and they navigated their marriage within a very traditional framework. However, as the years passed, the cultural friction between Michael's upbringing and Layla's family expectations began to erode the relationship. In 2026, the digital landscape plays a massive role in how this friction is managed. Social media platforms like TikTok and Instagram have become hubs for destigmatizing divorce within the community. There are now influencers and professional counselors specifically focusing on Muslim divorce, providing a digital support network that didn't exist 10 years ago. When Layla sees other women sharing their stories of life after divorce, it normalizes her own feelings of dissatisfaction. The open loop of her community's judgment is being closed by a global digital community that prioritizes mental health over social conformity. This leads us to the concept of the double divorce. In 2026, a growing number of couples are finding themselves in a state of legal and religious limbo. They might obtain a civil divorce through their state court, which handles the division of property, child support, and custody. But in the eyes of their religious community, they may still be considered married if they haven't obtained an Islamic divorce. This is where the tension between the husband's right to issue a talaq and the wife's right to seek a khula becomes a major point of contention. We are seeing more and more cases where a husband might use the withholding of a religious divorce as a bargaining chip in civil court negotiations, a practice that is increasingly being condemned by modern imams and advocacy groups as spiritual abuse. The evolution of the third space, the community centers and professionalized mosques, is a direct response to this crisis. In 2026, many of the larger Islamic centers in major U.S. cities have moved away from the uncle network approach to conflict resolution. In the past, a couple in trouble might have been sent to a group of elders who would simply tell them to be patient and pray more. Today, those same centers are hiring licensed clinical social workers and professional mediators who understand the psychological complexities of modern marriage. These professionals are trained to identify signs of domestic violence, narcissism, and deep-seated incompatibility that an untrained volunteer might miss. They are also working to create standardized marriage contracts that are legally robust and fair to both parties, aiming to prevent the legal limbo that has plagued so many families. But even with these advancements, the transition is far from smooth. There is a profound generational divide in how divorce is perceived. While the younger generation views it as a necessary, albeit painful, tool for personal growth and safety, many in the older generation still see it as a stain on the family's honor. This friction often plays out in the battle over child custody. 2026, U.S. courts are seeing more cases where religious upbringing is a contested issue. How does a judge in Michigan or Florida decide on a custody arrangement when one parent wants the children to attend a full-time Islamic school and the other prefers a secular public education? These are not just legal questions. They are deep, cultural questions about identity and the future of the American Muslim diaspora. We are also seeing a shift in the financial implications of divorce beyond the mar. As more couples accumulate wealth through 401ks, real estate and digital assets, the question of zakat and the religious obligation to support a former spouse becomes more complex. How do you reconcile the Islamic principle that a husband's financial responsibility ends after the iddah period, usually 3 months, with a U.S. court's order for long-term alimony? This is a point of significant friction that requires a sophisticated understanding of both systems. As we move forward in this deep dive masterclass, we have to ask ourselves, is the American Muslim community prepared for the reality that the traditional family structure is being replaced by something entirely new? What happens when the religious authorities and the state laws are in direct conflict, and who gets caught in the crossfire? In the next part of this series, we are going to look at the shadow courts, the informal Sharia councils operating across the United States. We will explore how they function, their lack of legal standing in the U.S., and the controversial role they play in either resolving or exacerbating the double divorce crisis. We will also examine a high-profile case study from 2025 that sent shockwaves through the community, involving a multi-million-dollar asset dispute that started in a mosque and ended in the Supreme Court of a major U.S. state. How much power does an imam really have over your bank account and your children? The answer might surprise you. To understand the true weight of the religious authorities in the United States, we have to look at the phenomenon often referred to as shadow courts. These are not dark, clandestine rooms, but rather the internal mediation committees and Sharia councils that operate within the walls of local mosques and Islamic centers across the country. In 2026, these councils are busier than ever, yet they operate in a legal gray zone that creates a massive amount of confusion for families. Imagine a couple in Dearborn, Michigan. Let's call them David and Amina. They have been married for 15 years and have built a significant life together, including a successful dental practice, 3 rental properties, and a diversified investment portfolio. When their marriage began to dissolve in late 2025, they first turned to their local Sharia council, hoping for a resolution that aligned with their faith. The council, composed of 3 respected community leaders and an imam, reviewed their case. From a traditional religious standpoint, the council suggested a division of assets that heavily favored the preservation of the ancestral property David had inherited, while offering Amina her deferred mahr of $30,000. To the council, this was a fair application of classical Islamic jurisprudence. But here is where the friction begins. In the United States, these religious rulings have zero inherent legal standing, unless both parties have signed a legally binding arbitration agreement that complies with the specific requirements of the Federal Arbitration Act or relevant state laws. The council's decision is nothing more than a recommendation. In the case of David and Amina, when Amina realized that her state's law of equitable distribution would likely grant her 50% of the entire marital estate, including the growth in value of the rental properties and the dental practice, the religious ruling suddenly looked very different. This dynamic creates what many legal scholars call the competition of forums. We are seeing a historical trend where individuals choose the forum, either the state court or the Sharia council, that offers them the most favorable outcome. This is not just a matter of greed. It is a matter of survival and fairness in a modern economy. If you are Amina in 2026, you are looking at a future where you need to maintain your professional standing and provide for your children in a high-inflation environment. The traditional religious interpretation of financial maintenance, which often ends after the 3-month period, simply does not align with the reality of raising a family in an American suburb. Step by step, let's look at how this process often breaks down. First, the couple attempts mediation at the mosque. If the mediation fails or if one party feels the outcome is unjust, they then file for a civil divorce in state court. At this point, the religious council often loses all leverage. However, the social consequences remain. In many tight-knit communities, if David refuses to grant a religious divorce despite the state court's final decree, Amina finds herself in a state of being an anchored woman, or a woman who is civilly free but religiously chained. She cannot remarry within her faith community without that religious certificate. This is where the imam's power is most felt. Not in your bank account, but in your social and spiritual life. The 2025 case study of a high-profile asset dispute in Texas perfectly illustrates the limits of an imam's power over finances. A prominent businessman attempted to use his mosque's mediation ruling to shield millions of dollars from his wife during their civil divorce. He argued that since they both agreed to the mosque's authority at the start of their marriage, the state court should defer to the religious ruling. The Texas court's response was a landmark moment for 2026 legal standards. The judge applied the neutral principles of law doctrine, which states that a court can resolve a dispute involving a religious organization if it can do so by relying on neutral, secular legal principles without delving into religious dogma. The court ruled that the religious agreement did not meet the rigorous standards of a Texas prenuptial agreement because it lacked full financial disclosure and independent legal counsel for both parties. The result? The religious ruling was completely set aside, and the state's community property laws were applied. This leads us to a critical realization for anyone navigating this space in 2026. An imam has as much power over your bank account as you choose to give him through a legally enforceable contract. Without a valid, secularly recognized agreement, an imam cannot garnish your wages, seize your property, or dictate your child support payments. However, the power they hold over child custody is a much more nuanced and emotional battleground. While U.S. courts always use the best interest of the child standard, they are increasingly being presented with arguments regarding the religious and cultural identity of the children. Imagine if David argues in court, giving Amina primary custody would lead to the children losing their connection to their faith, because she has become less observant post-divorce. In 2026, judges are becoming more sophisticated in handling these arguments, but the emotional toll on the family is immense. We are also seeing a shift in how imams themselves view their role. A new generation of American-born and trained imams is increasingly hesitant to get involved in financial or custody disputes. They have seen the potential outcomes of being sued or brought into depositions as witnesses. Historical trends show that mosques are now frequently including disclaimers in their mediation intake forms, explicitly stating that their role is spiritual and that parties should seek legal counsel for all civil matters. This professionalization is a direct result of the high-stakes litigation that has defined the last few years. But what about the psychological impact? When a couple enters a Sharia council, they are often seeking a sense of closure that the state court cannot provide. They want to know they are right in the eyes of God. When the state court provides one answer and the religious council provides another, it creates a deep sense of cognitive dissonance. This is the heart of the cultural shift. The American Muslim community is moving away from a model where one authority figure holds all the answers, toward a more fragmented reality where individuals must navigate multiple, often conflicting, systems of justice. Consider the role of the mahr in this conflict. In the past, the mahr was a straightforward gift. In 2026, it is a complex legal instrument. If a woman waives her right to civil alimony in exchange for a large mahr in a religious setting, will the state court honor that waiver? The answer is often no, unless it was part of a broader, secularly valid prenuptial agreement. This brings us to a major open loop in our deep dive. Many couples believe their nikah is a shield, but in the hands of a skilled divorce attorney, it can often become a sword. As we continue this masterclass, we have to look closer at the document that starts it all. We have discussed the power of the councils and the courts, but what about the fine print of the contract itself? In the next part, we are going to expose the mahr trap. We will look at how a document designed to protect women is being used against them in modern courtrooms to limit their civil rights. We will also examine how men are being caught off guard by deferred mahr payments that they thought were merely symbolic, but which are now being enforced as high-interest debts. What happens when a 1,000-year-old tradition meets a 21st-century debt collector? The legal reality is more aggressive than you think. We will break down the specific clauses that are currently causing the most chaos in U.S. courts, and how to ensure your religious identity doesn't cost you your financial future. The legal reality is more aggressive than you think. To truly understand the mahr trap in 2026, we have to look at how a document intended for spiritual sanctity is being dissected under the cold, clinical lights of a United States courtroom. The mahr, traditionally seen as a gift of honor to the bride, is increasingly being treated by state judges as a secular debt instrument or a prenuptial agreement. This transition from a religious obligation to a civil liability is where many American Muslim families are finding themselves blindsided. Imagine a woman named Fatima living in Los Angeles in 2026. Fatima is a 38-year-old marketing director who has been married to her husband, Yusuf, for 12 years. When they married in a local community center in 2014, their nikah specified a deferred mahr of $75,000. At the time, Yusuf was a graduate student with very little to his name, and the number felt like a symbolic gesture of his future intent to provide. However, as they enter the divorce process in 2026, Yusuf's legal team is using that very document as a shield to deny Fatima any further spousal support. Their argument is based on a historical trend in certain California jurisdictions where if a mahr is high enough, the court may view it as a full and final settlement of all financial claims between the spouses. Fatima, who expected the mahr to be in addition to her civil rights, suddenly finds herself in a position where the religious contract might actually limit her recovery under state law. This is the first edge of the mahr trap. When the religious contract is interpreted as a waiver of secular rights that the parties never intended to sign away. Now let's flip the perspective and look at the second edge of the trap through the eyes of a man we will call Hassan, a successful pharmacist in New Jersey. Hassan married his wife Miriam in 2018. Like many young men at the time, he was pressured by family elders to agree to a substantial deferred mahr, $100,000, to show his seriousness. He was told it was just a formality, and that it would only ever be paid in the event of his death or a rare divorce. In 2026, as the marriage dissolves, Hassan is shocked to find that New Jersey courts, following established case law, may view that $100,000 figure as a liquidated debt. Unlike an equitable distribution of assets where the court looks at what both parties contributed during the marriage, a mahr debt is often viewed as a fixed obligation that must be paid regardless of the current financial situation. Hassan is now facing a scenario where he must liquidate his retirement accounts and sell his car just to settle a religious contract he was told was merely symbolic. The step-by-step reality of how this plays out in a 2026 courtroom is a masterclass in legal complexity. The process usually begins during the discovery phase of the divorce. The opposing counsel will demand a copy of the nikah. If the document is in Arabic or Urdu, the court will require a certified translation. This is where the first set of problems arises. Translation is not just about words, it is about intent. One translator might use the word gift, while another uses the word debt or dowry. In a U.S. court, these words have radically different legal implications. A gift might not be enforceable as a contract, but a debt is. Once the document is translated, the court must determine its validity under the state's contract laws. In 2026, judges are looking for three specific things: offer, acceptance, and consideration. They are also looking at the circumstances under which the contract was signed. If Fatima signed the nikah 10 minutes before the wedding ceremony while surrounded by guests, and without the opportunity to consult a lawyer, her attorney might argue that the contract was signed under duress, or that there was a lack of full financial disclosure. Historical trends in case studies from 2024 and 2025 show that courts are increasingly throwing out mahr clauses that do not meet the rigorous standards of a secular prenuptial agreement. However, if the court finds the contract valid, the financial impact can be devastating for the party who didn't take the paperwork seriously. We are also seeing the emergence of the expert witness industry within Muslim divorce cases. In 2026, it is common for both sides to hire academic scholars or imams to testify about the meaning of specific terms like muajjal, which refers to prompt mahr, and muakkar, which refers to deferred mahr. The cost of this expert testimony can run into the thousands of dollars, further draining the marital estate. These experts often disagree, leaving a secular judge, who may have no background in Islamic jurisprudence, to decide which religious interpretation is more credible. This often leads to potential outcomes that satisfy neither party and leave both feeling that their faith has been misunderstood by the legal system. Another layer of the trap involves the timing of the payment. In many Islamic traditions, the mahr is only due upon divorce or death. But when does the divorce officially happen? Is it when the husband utters the talaq? Is it when the religious council issues a certificate? Or is it when the state judge signs the final decree? In 2026, this timing issue is a major point of litigation. If the mahr is considered a debt that becomes due upon divorce, and the couple separates but remains legally married for 2 years during a contested case, does interest accrue on that debt? We are seeing cases where attorneys are arguing for the application of state-mandated interest rates on unpaid mahr balances, turning a religious obligation into a ballooning financial liability. The psychological weight of the mahr trap cannot be overstated. For many, the mahr represents their worth or their commitment. When it becomes a weapon in a courtroom, it poisons the well of community trust. We are seeing a cultural shift where younger couples in 2026 are moving away from the traditional nikah entirely. Instead, they are opting for dual-purpose contracts, Islamic prenups that are drafted by a team of both a family law attorney and a religious scholar. These documents are designed to be enforceable in a U.S. court, while still fulfilling the religious requirements of the faith. They include clear language regarding asset division, alimony waivers, and the specific nature of the mahr, ensuring that there are no surprises when the secular and religious worlds collide. But for those who did not have the foresight to draft such a document, the 2026 legal landscape is a minefield. We are seeing a rise in what is being called the mahr offset. This is where a judge, in an effort to be fair, will award the wife the mahr but then subtract that exact amount from her share of the marital home or the husband's pension. This essentially renders the mahr financially meaningless, as it is simply a reallocation of money the woman would have received anyway under state law. This realization often leads to a deep sense of betrayal for women who believed the mahr was an independent right protected by their faith. As we peel back these layers, it becomes clear that the mahr is no longer just a private matter between a husband and wife. It is a public, legal, and economic reality that requires a new level of sophistication. The historical trends are pointing toward a future where the religious marriage contract is either fully secularized by the courts or rendered irrelevant by the complexity of its own terms. But as intense as the financial battle is, It is often just the opening act for a much more visceral struggle. While bank accounts can be emptied and assets can be sold, there is one area of divorce where the stakes are infinitely higher and the tactics become even more aggressive. In the next part of this masterclass, we are going to dive into the most sensitive topic of all, the weaponization of the kids. We will look at how religious identity is being used as a tactical advantage in custody battles, the rise of religious alienation as a legal strategy, and what happens when the best interests of the child are defined through the lens of competing cultural expectations. How do you protect your children when their very faith is put on trial? The details of these 2026 custody cases will change the way you think about family law forever. When we speak of the weaponization of children in the context of 2026 divorce proceedings, we are entering a territory where the emotional stakes are unparalleled. In the United States, the gold standard for custody is the best interest of the child. On the surface, this sounds like a neutral, compassionate framework. However, when you overlay the complexities of religious identity and cultural preservation, this neutral standard becomes a high-intensity battleground. In 2026, we are seeing a dramatic rise in cases where one parent's religious practice, or lack thereof, is cited as a primary factor in determining fitness for custody. This is not just about who gets the kids on weekends. It is about who has the legal authority to shape the child's worldview, their diet, their social circle, and their very soul. Imagine a case in suburban New Jersey involving a couple we will call Robert and Jamila. Robert, who converted to Islam a decade ago, has become increasingly secular following the breakdown of the marriage. Jamila, on the other hand, has found deeper solace in her faith. As they move through their 2026 divorce, the central conflict is not the house or the savings accounts, but their 7-year-old daughter's education. Jamila wants her enrolled in a full-time private Islamic academy to ensure she maintains her cultural and religious roots. Robert argues that this environment is too insular and that their daughter should attend the local public school to better integrate into the broader American society. In a 2026 courtroom, a judge is tasked with deciding which path serves the child's best interest. Historically, courts have tried to remain religiously neutral, following the parental choice doctrine, which suggests that parents have a fundamental right to direct the religious upbringing of their children. But when parents disagree, the court is forced to step in. Jamila's legal team might present expert testimony from a child psychologist who argues that continuity in the child's religious community is essential for her emotional stability during the trauma of divorce. Conversely, Robert's attorney might cite historical trends in Michigan or New York, where judges have ruled that exposing a child to a diverse, secular environment is better for their long-term social development. This is the first layer of the battle: the use of secular psychological theories to justify or challenge religious lifestyles. Step by step, we see this weaponization evolve into something called religious alienation. This is a 2026 adaptation of the well-known concept of parental alienation. In this scenario, one parent may subtly or overtly convince the child that the other parent is an apostate or a bad Muslim because they no longer fast during Ramadan, or because they have started dating. Imagine if Jamila tells her daughter that her father's new lifestyle is a sin. This can create a deep psychological rift, where the child feels that loving the secular parent is a betrayal of their faith and their other parent. In a 2026 custody evaluation, a court-appointed guardian ad litem would be looking for these signs of influence. If the court finds that one parent is using religion to destroy the child's relationship with the other, the potential outcomes can be severe, including the loss of primary physical custody or court-ordered reunification therapy. We are also seeing the rise of the cultural expert witness. In 2026, high-stakes divorce cases often involve specialized anthropologists or sociologists who are paid to explain to a secular judge why certain religious practices are vital. For example, in a case involving a family from a traditionalist background, an expert might explain that for a daughter, being raised in a household that observes strict gender boundaries is not a sign of oppression, but a cultural norm that provides the child with a sense of security and identity. The opposing side might bring their own expert to argue that these same boundaries limit the child's future opportunities in the United States. The judge, who may have no personal experience with these cultural nuances, is left to weigh these competing expert opinions. Another critical area of concern in 2026 is the shadow of international abduction. In high-conflict divorces where one parent has strong ties to a country that is not a signatory to the Hague Convention on the Civil Aspects of International Child Abduction, the fear of a parent fleeing the country with the children is a constant undercurrent. Historical trends show that judges are increasingly willing to impose strict travel bans and require the surrender of passports during the pendency of a divorce. Imagine a father in Houston who is restricted from taking his children to visit their grandparents in a non-hate country because the court deems him a flight risk. The legal strategy here involves filing for an exit order, which literally means he cannot exit. This creates a scenario where the children's relationship with their extended global family is sacrificed on the altar of legal precaution. Furthermore, we are seeing the emergence of the religious clause in modern parenting plans. In 2026, attorneys who specialize in Muslim divorce are drafting incredibly specific documents. These are no longer general agreements to raise children in the faith. They are granular. They specify who will pay for the Hajj fund, which mosque the children will attend, what level of halal certification is required for their food, and exactly how holidays like Eid al-Fitr and Eid al-Adha will be split, down to the hour. If one parent violates these specific religious provisions, it can be treated as a contempt of court, just like a failure to pay child support. This level of detail is a direct response to the ambiguity that led to so many legal battles in the early 2020s. The psychological toll on the children in these 2026 cases is profound. They often find themselves in a loyalty conflict, where every choice, from what they eat at a birthday party to what they say in their evening prayers, is a potential landmine in their parents' legal war. We are seeing a rise in children's advocates who are specifically trained in cross-cultural conflict to help these kids navigate the two worlds they inhabit. The data suggests that children who are used as pawns in religious custody battles often experience higher rates of anxiety and a subsequent distancing from the faith itself as they reach adulthood, viewing the religion not as a source of peace, but as the catalyst for their family's destruction. But what happens when the conflict isn't just about the kids or the money? What happens when the very safety of one spouse is at risk, and the traditional community structures that are supposed to protect them are the ones standing in the way? As we look at the cultural shifts of 2026, we have to confront the darkest corner of this deep dive. While custody battles are public and loud, there is a silent parallel struggle happening in the shadows of the community. In the next part of this masterclass, we are going to expose the secret divorce and the reality of domestic violence. We will look at how the concept of sabr or patience has been historically used to silence victims, and how a new movement of survivors is using U.S. civil law to break the chains of spiritual abuse. We will examine the controversial role of the religious decree as a tool of liberation, and how some are still using it as a final, desperate form of control. The shift from silence to the courtroom is changing the face of the community forever. The shift from silence to the courtroom is changing the face of the community forever, particularly when we address the intersection of domestic violence and the misinterpreted virtue of sabr, or patience. In 2026, the American Muslim community is undergoing an agonizing, but necessary reckoning with how religious concepts have been historically weaponized to keep survivors in dangerous or depleting environments. For decades, the word sabr was often whispered as a directive for endurance, a command to stay for the sake of the children or the reputation of the family. However, a profound cultural shift is replacing this narrative of silent suffering with a framework of survival and legal empowerment. Imagine a woman in Atlanta, Georgia, whom we will call Maya. It is March 2026, and Maya has spent nearly a decade in a marriage characterized by what experts now formally categorize as spiritual abuse and coercive control. Her husband, a respected member of the local business community, does not use physical violence that leaves visible marks. Instead, he uses the language of faith as a cage. He tells her that a righteous wife does not question her husband's financial decisions, even when he drains their joint savings. He tells her that her desire to work outside the home is a sign of weak faith. When she finally seeks counsel from an elder in her community, she is told to be patient, to pray more, and to remember that the most hated of all permissible things in the eyes of God is divorce. This scenario represents the traditional wall that many survivors hit. But in 2026, Maya's story takes a different turn because of the evolving legal literacy within the diaspora. Step by step, we are seeing survivors move away from private religious mediation and toward the public protection of the U.S. civil court system. Maya realizes that while the mosque may offer spiritual solace, it cannot issue a temporary protective order or TPO. In Georgia, as in many other states, the legal definition of family violence has expanded to include emotional and psychological abuse that places a person in reasonable fear of safety. Maya's first step in 2026 is not to the imam, but to a civil attorney who specializes in the intersection of domestic law and cultural nuance. Historical trends show that between 2020 and 2026, there has been a 40% increase in Muslim women seeking civil restraining orders before ever initiating a religious divorce. This is a massive departure from the past. By securing a civil protection order first, Maya creates a legal perimeter that the community is forced to respect. If her husband violates the TPO by showing up at the mosque to intimidate her, he faces immediate arrest under state law. This civil shield provides the breathing room necessary to tackle the much more complex issue of the religious divorce. This brings us to the controversial and often painful process of the secret divorce or the fash. In 2026, a growing number of women are finding themselves civilly divorced but religiously chained because their husbands refuse to grant a talaq. This is where the concept of spiritual abuse reaches its peak, using a religious right to exert final desperate control over an ex-spouse's future. In response, a new movement of American imams and scholars is standardizing the process of judicial annulment within the United States. In Maya's case, after her civil divorce is finalized in a Fulton County court, her husband still refuses to sign the religious papers. In 2026, Maya can now turn to a regional Sharia council that operates with a domestic violence protocol. These councils no longer require the husband's presence if there is documented evidence of abuse from a civil court. They are increasingly recognizing that a U.S. civil divorce decree, which incorporates findings of cruelty or abandonment, is sufficient grounds for a religious annulment. This is a revolutionary shift. It effectively decouples a woman's spiritual freedom from her abuser's whim. However, the path is fraught with social consequences. Maya may find herself ostracized by those who still view her pursuit of legal protection as bringing shame to the community. This is where the 2026 data on transitional housing and support networks becomes critical. Organizations like the Asiya Women's Center or Nisa Homes have seen a surge in demand, not just for beds, but for legal advocacy. These groups provide the infrastructure that the mosque often cannot, offering survivors a bridge from a life of controlled silence to a life of independent agency. We must also look at the role of the civil attorney in these high-stakes cases. In 2026, savvy lawyers are using evidence of spiritual abuse as a tactical element in custody and asset division. If a husband has used religious threats to isolate a wife from her family, an attorney may argue that this constitutes a pattern of behavior that makes him an unfit primary conservator under the best interests of the child standard. This is the legal system's way of saying that religious freedom does not provide a license for psychological torment. The potential outcomes for children in these situations are being studied with more intensity than ever before. Case studies from 2025 and 2026 suggest that children who witness a parent successfully navigate the legal system to find safety have a much more resilient relationship with their faith later in life. They see that justice is an active pursuit, not just a passive endurance. Conversely, when children see a religious community protecting an abuser under the guise of family unity, they often develop a deep-seated resentment toward the faith itself. But there is another layer to this cultural shift that is just beginning to surface. As women like Maya gain their freedom through the courts, they often face a new secondary crisis, the economic aftershock. In a high-inflation 2026 economy, leaving a marriage often means moving from a dual-income household or a supported position into a state of sudden financial vulnerability. The community's focus on the morality of divorce often ignores the raw mathematical reality of how these women will survive the next 5 years. We are seeing a rise in what some scholars call the poverty trap of the divorcee. Even with a MAR settlement and an equitable distribution of assets, the cost of living in major U.S. hubs like Northern Virginia, Houston, or Southern California can quickly evaporate a woman's savings. This is particularly true for those who have been out of the workforce for years due to marital expectations. As we continue this masterclass, we have to look beyond the courtroom battles and the religious decrees. We have to look at the bank statements in the job market. The shift from silence to the courtroom is only half the battle. The other half is the struggle for economic stability in a world that wasn't built for the single Muslim mother. What happens when the legal fees exceed the total value of the MAR? How do you rebuild a career at 40 with 3 children and a community that still views you through a lens of pity? In the next part of this series, we are going to break down the economic aftershock. We will look at the hidden costs of divorce that no one talks about, from the sudden loss of health insurance to the impact on credit scores and the reality of the single-parent tax. We will also examine a growing trend in 2026, the rise of the Muslim professional network designed specifically to help divorced women re-enter the workforce. The financial jihad is real, And the numbers are more daunting than the legal papers. How do you secure your future when the institution you relied on has crumbled? The answer lies in a new kind of financial literacy that is taking the community by storm. The financial literacy taking the community by storm is born out of a cold, hard necessity that many American Muslim women are facing for the first time in 2026. For decades, the financial conversation within the marital home was often a closed book, a one-sided ledger managed by the primary breadwinner. But as the divorce rates climb, the realization has set in that spiritual righteousness does not pay the rent in a high-inflation economy. To understand the depth of this economic aftershock, we must look at the life of someone like Zainab, a 44-year-old mother of 3 living in the high-cost borough of Brooklyn, New York. Imagine Zainab in early 2026. After 16 years of marriage as a dedicated stay-at-home parent, her world has shifted from managing a household to managing a legal battle. In her mind, she felt secure because of her deferred mahr of $50,000. To many, $50,000 sounds like a substantial sum. However, in the 2026 New York City rental market, where a safe 3-bedroom apartment for her and her children easily commands $6,000 a month, that mahr is not a retirement fund. It is barely 8 months of housing. This is the first lesson in the new financial literacy. The religious dowry is a safety net made of thin silk, not reinforced steel. Step by step, the economic reality of divorce begins with what we call the hidden bill. In the United States, the cost of a contested divorce in 2026 has ballooned. Historical trends show that attorney retainers in major metropolitan areas now start at $5,000 to $10,000 just to open a file. With hourly rates ranging from $400 to $700, a prolonged battle over assets can easily evaporate $20,000 before a single court date is even set. For someone like Zainab, who may not have had independent access to joint bank accounts, the first hurdle is not just legal, it is the immediate lack of liquidity. This has led to a rise in specialized legal funding groups within the community that provide microloans to women to ensure they can afford competent representation. Furthermore, we have to talk about the single-parent tax. This is not a literal government levy, but the cumulative financial burden of moving from a dual-income or shared resource household to an isolated economic unit. When Zainab was married, the family shared one health insurance plan, one car insurance policy, and a single mortgage or rent payment. After the split, her health insurance premiums under COBRA might spike to over $1,000 a month. Her childcare costs, which were previously mitigated by her presence at home, now become a massive line item as she seeks to re-enter the workforce. In 2026, the data indicates that divorced women in the American Muslim community experience an average 30% drop in their standard of living within the first year, whereas men often see a slight increase or stabilization. This disparity has sparked the professional re-entry movement. Imagine the psychological mountain Zainab has to climb. Her resume has a 16-year gap. In the 2026 job market, dominated by rapid advancements in artificial intelligence and specialized technical skills, she feels like a relic. However, the cultural shift we are tracking has produced a solution: the rise of professional mentorship networks. We are seeing groups like the Muslim Women's Professional Network creating specific tracks for divorcees. These programs don't just offer sympathy. They offer intensive boot camps in digital literacy, project management, and financial planning. They recognize that for Zainab, the best form of protection is a career that provides her own 401k and health benefits. Deep diving into the numbers, we also see the complexity of the QDRO, or the Qualified Domestic Relations Order. Many people navigating divorce in 2026 are unaware that they may be entitled to a portion of their spouse's retirement accounts, even if those accounts are in the spouse's name only. Historically, many women in the community walked away with only their mahr, unaware that state laws often view retirement savings as marital property. The new financial literacy involves educating women on how to secure these long-term assets. It's about understanding that a $100,000 401k split is often worth far more over 20 years than a one-time cash payment of $20,000. But there is a spiritual financial conflict that arises here as well. In 2026, many women face a moral dilemma regarding alimony. Traditional interpretations often suggest that a husband's financial obligation ends after the iddah period. Yet, U.S. law may grant spousal support for years, especially in long-term marriages. We are seeing a fascinating case study in how women navigate this. Some choose to take only what is religiously prescribed, while others argue that in the context of the American economy, where they sacrifice their earning potential for the marriage, The civil law's version of alimony is the only way to achieve true justice. This has led to intense debates within mosques about whether civil alimony can be considered a form of the Islamic concept of mut'a, or a parting gift of maintenance. We must also consider the credit score crisis. In many traditional households, the credit cards and utilities are all in the husband's name. When a woman like Zainab leaves, she often finds she has no credit history, making it impossible to lease an apartment or buy a car in her own name. The 2026 trend is for women to begin building independent credit years before a marriage even shows signs of trouble, a move that was once seen as a lack of trust but is now viewed as basic financial hygiene. This economic shift is also changing the way the community handles charity. In 2026, there is an ongoing discussion about the eligibility of divorced women for zakat. Historically, zakat was often funneled toward international causes or mosque expansions. Today, there is a growing push to keep those funds local, creating endowment funds specifically for divorced mothers to prevent them from falling into poverty. Case studies from cities like Dallas and Chicago show that these local funds have successfully prevented homelessness for dozens of families who were caught in the gap between a civil decree and the actual receipt of funds. As we look at these moving pieces, it's clear that the financial jihad is not just about earning money, it's about the literacy required to keep it and grow it. The community is moving away from the idea that a woman's financial security is someone else's responsibility. But as Zainab secures her bank account and restarts her career, she encounters a different kind of wall. One that isn't built of numbers or laws, but of whispers and closed doors. The economic battle is a fight for survival, but the social battle is a fight for belonging. What happens when your financial independence makes you a threat to the traditional social order? Why is it that in 2026, a divorced woman with a high-paying job is often viewed with more suspicion than one who is struggling? In the next part of this series, we are going to explore the pity or pariah syndrome. We will look at the brutal social hierarchy of the post-divorce world, the reality of the second marriage market, and how the community's obsession with family honor is creating a new class of social outcasts. We will examine the secret support groups where women share the truth about who stayed and who left when the marriage ended. The social cost of freedom is higher than the legal fees, and we are going to show you exactly how it's being paid. The social cost of freedom is higher than the legal fees, and we are going to show you exactly how it's being paid. To understand the pity or pariah syndrome in 2026, we have to look at the invisible social hierarchy that governs the American Muslim community after a marriage dissolves. While the legal system views divorce as a civil transaction, the community often views it as a moral or cultural bankruptcy. This creates a binary experience where the divorced individual, particularly the woman, is either treated as a tragic victim to be pitted and managed, or a dangerous outsider to be avoided. Imagine a woman named Layla living in a high-tech suburb of Seattle in 2026. Layla is a 36-year-old AI ethicist who finalized her divorce 6 months ago. She is financially independent, emotionally resilient, and has secured a fair custody arrangement for her 2 children. By all secular metrics, she is a success story. However, when she walks into her local community center for a Friday lecture, the atmosphere shifts. This is the pariah effect. Historical trends in 2026 show that divorced women are often subtly excluded from the social circles of married women. There is a persistent, underlying fear of contagion, the idea that if one woman finds happiness and stability after leaving a difficult marriage, others might be inspired to reevaluate their own. Layla finds that the invitations to the weekend dinners and the sisterhood coffee circles have evaporated. She has become a reminder of the fragility of the marital institution, and in a community that prizes family stability above all else, her presence is an uncomfortable mirror. Step by step, the isolation begins with the couple's circle. In most American Muslim communities, social life is organized around pairs. When you are no longer half of a pair, you lose your seat at the table. This is not just a loss of friendship, it is a loss of networking and community support. For Layla, this means she is no longer privy to the informal information exchanges that happen in these circles. The recommendations for the best tutors, the news about local job openings, or the heads-up about community grants. The social death of divorce is a cumulative process where the individual is gradually erased from the collective memory of the group. On the other side of the coin is the pity syndrome. Imagine if Layla's community didn't shun her, but instead treated her as a perpetual project. This is the infantilization of the divorcee. Well-meaning elders and acquaintances approach her with a tone of voice usually reserved for the grieving. They offer unsolicited advice on how she should dress to be more appealing for a second marriage, or they suggest she lower her standards significantly because, in their eyes, she is now used goods. In 2026, this rhetoric is increasingly being challenged by the younger generation, but the historical weight of these cultural attitudes remains a heavy burden. The message is clear. Your value as a human being is inextricably linked to your marital status, and without a husband, you are a broken entity in need of repair. This leads us to the brutal reality of the second marriage market in 2026. Data from major Muslim matrimonial apps like Muzz and Salam shows a fascinating and troubling trend. Even as the community becomes more professional and educated, the filter for divorce remains one of the most frequently used. For a man like Adam, a 42-year-old cardiologist in Houston who is also divorced, the market is vastly different. Historical trends suggest that a divorced man with a high income and a stable career is often recruited for marriage almost immediately, sometimes to women who have never been married before. The stigma for men is significantly lower. His divorce is often viewed as a temporary setback or the fault of a difficult ex-wife. However, for a woman like Layla, the market is a landscape of double standards. In 2026, she is often told that she should be grateful for any interest at all, especially since she has children. There is a pervasive cultural myth that children from a previous marriage are a burden to a new husband, rather than a part of a new family unit. We are seeing case studies where women are pressured to give up their primary custody or waive their child support, just to make themselves more attractive to potential suitors. The potential outcomes of this pressure are devastating, often leading women into second marriages that are even more restrictive or imbalanced than the first, simply to escape the social stigma of being alone. But the 2026 landscape is not entirely bleak. A new form of digital resilience is emerging. Layla doesn't just sit in the silence of her social isolation. She joins a private, encrypted signal group of over 200 other professional divorced Muslim women in the Pacific Northwest. This is the rise of the shadow sisterhood. These groups serve as an alternative community where women exchange more than just emotional support. They share the names of fair-minded imams who will facilitate a religious remarriage without making it an interrogation. They recommend attorneys who understand how to protect a woman's assets in a second marriage. They even coordinate their own social events, creating a new, vibrant social tier that exists entirely outside the traditional mosque structure. The social cost of freedom also involves the extended family. In 2026, the concept of ghaira or honor still plays a significant role in how a divorce is handled. Layla's parents, despite living in the United States for 40 years, feel a deep sense of shame regarding her divorce. They worry about what their cousins in Lahore or London will think. This creates a secondary layer of conflict where the divorcee has to manage the emotional fallout of their parents, while simultaneously rebuilding their own life. We are seeing a trend where divorced individuals move to different cities, from Chicago to Dallas, or from New York to Charlotte, not for jobs, but for a fresh start where they aren't defined by their past marital status. Furthermore, we must examine the impact on the children's social standing. In 2026, the children of divorce often face their own set of social hurdles. They may be excluded from certain playdates or viewed with suspicion by more traditional parents, who fear that the broken home environment will negatively influence their own children. This social filtering is subtle but pervasive. It requires a high level of emotional intelligence from the parent to navigate these waters without letting the children feel the weight of the community's judgment. As Layla and Adam navigate these two very different social paths in 2026, a deeper question begins to emerge. It is a question that moves beyond the social circles and the matrimonial apps. It is a question of the soul. When the community shuns you, and the family elders pity you, where do you turn for spiritual validation? Many are starting to ask, is the God I worship the same God the community uses to judge me? As we approach the final stages of this deep dive masterclass, we have to confront the ultimate authority. We have looked at the laws, the money, the kids, and the social fallout. But what about the faith itself? In the next part of this series, we are going to dive into the spiritual crisis and the new jurisprudence. We will look at how the 2026 generation is reclaiming Islamic history to justify their modern choices, the rise of the female mufti, and the controversial movement to reform the very definitions of marriage and divorce within the American context. Is it possible to be a devout Muslim and a two-time divorcee in the eyes of the modern mosque? The answer involves a radical rereading of ancient texts that is sending shockwaves through the global Islamic community. The struggle for the soul of the faith is the final frontier. The struggle for the soul of the faith is the final frontier, And in 2026, it is being fought not in the halls of ancient universities, but in the living rooms of American suburbs and on encrypted messaging apps where a new jurisprudence is taking root. For the American Muslim navigating divorce, the greatest hurdle is often the internal voice that asks, "Am I failing God by leaving this marriage?" This spiritual crisis is the catalyst for a radical movement that is reclaiming Islamic history to justify modern survival. To understand this, we must look at the life of someone like Hannah, a 39-year-old healthcare administrator in Columbus, Ohio. Imagine Hannah in the spring of 2026. She has spent 3 years in a state of spiritual paralysis, feeling that her desire for a divorce was a sign of a deficiency in her faith. In her local community, the dominant narrative she heard was that the throne of God shakes when a marriage ends. But Hannah began to dig deeper. She joined a digital study circle led by a new generation of female scholars, often referred to as alimas or even female muftis, who hold traditional ijazas or authorizations but apply them to the American context. These scholars are pointing Hannah toward historical trends that have been largely ignored by the patriarchal immigrant culture of the last 50 years. Step by step, Hannah is learning that the early Muslim community in 7th century Medina was significantly more fluid and less stigmatizing regarding divorce than her current community in Ohio. She discovers the stories of the Sahabiyat, the female companions of the Prophet, many of whom were married and divorced multiple times without losing their social standing or their spiritual dignity. This historical reclamation is a massive cultural shift. It is the realization that the current stigma is a cultural import from specific geographic regions, South Asia, the Levant, North Africa, rather than an inherent requirement of the faith. By 2026, this distinction between culture and creed has become the primary weapon for those seeking spiritual liberation. The rise of the female religious authority is perhaps the most disruptive element of this new landscape. Historically, the interpretation of divorce law was the exclusive domain of men. In 2026, however, women are no longer content to have their lives decided by a committee of men who may not understand the nuances of emotional neglect or the complexities of modern mental health. We are seeing case studies where female scholars are issuing formal religious opinions, or fatwas, that recognize psychological well-being as a fundamental requirement of an Islamic marriage. They are arguing that if a marriage prevents an individual from fulfilling their spiritual potential or maintaining their mental health, the preservation of that marriage is no longer a religious priority. This is a total inversion of the Sabr narrative we discussed earlier. It suggests that true patience is the endurance required to build a healthy life, not the endurance of a toxic one. Consider the movement for the civil religious synthesis. In 2026, a growing coalition of American imams and legal scholars is pushing for a revolutionary change in how divorce is finalized. Their argument is simple but profound. In the United States, the civil divorce process is actually more aligned with the Islamic principles of justice and due diligence than the often arbitrary rulings of informal Sharia councils. They are advocating for a system where the signing of a U.S. civil divorce decree automatically serves as the religious divorce. This would eliminate the double divorce crisis and prevent the withholding of the talaq as a form of control. This movement, while controversial, is gaining traction because it solves the legal limbo that has devastated so many families over the last decade. Imagine the potential outcomes of this shift. If the civil decree is recognized as spiritually sufficient, the power of the shadow courts is effectively neutralized. The imam becomes a counselor and a spiritual guide rather than a judge of civil contracts. This is a move toward a more Protestantized model of Islam, where the individual's relationship with the law is mediated by the state, and their relationship with God is a private, spiritual matter. In 2026, this is not just a theoretical debate. It is a lived reality for thousands of people who are choosing to bypass traditional authorities altogether, confident that their civil papers are enough to satisfy their religious obligations. We are also seeing a reimagining of the nikah or marriage contract for the 2020s. This is the era of the contract of equals. These new documents, which are becoming standard in progressive American mosques, include explicit clauses that grant the wife the right to divorce, known as tafwid al-talaq, at the moment of marriage. By 2026, this is no longer seen as a sign of lack of trust, but as an essential safeguard for modern equity. The contract also specifies that any dispute will be settled by professional arbitration that follows U.S. law, ensuring that the religious and secular worlds are aligned from day one. This proactive approach is a direct response to the historical trends of messy, multi-year legal battles that characterized the early 2000s. However, This radical rereading of texts is meeting stiff resistance. There is a deep-seated fear among the traditionalist camp that this Americanized jurisprudence is a dilution of the faith. They argue that by making divorce easier and more socially acceptable, the community is losing its core identity and mimicking the high divorce rates of the broader secular society. This tension is creating a bifurcated community. In 2026, you can walk into one mosque in Dearborn and hear a sermon about the sanctity of the family at all costs, and then drive 20 minutes to another mosque and hear a lecture about the religious duty of a woman to leave an unfulfilling union. The struggle for the soul of the faith also extends to the concept of the second marriage. As the stigma of divorce is dismantled through scholarship, the community is having to grapple with the reality of blended families. In 2026, we are seeing the emergence of specific religious guidelines for step-parenting and the rights of children from previous marriages. This is a new frontier for Islamic law in the West. How do you apply 7th century inheritance and custody rules to a 21st century blended family in a country with a completely different legal infrastructure? The answers are being written in real time by scholars who are willing to use the principle of maslaha, or the public interest, to adapt the law to the needs of the time. Hannah, in her study circle in Ohio, represents the end of the line for the old ways. She is part of a generation that is no longer asking for permission to be whole. She is finding that the deeper she goes into the actual texts, the more she feels empowered to make the choices that are right for her and her children. The spiritual crisis that once paralyzed her has turned into a spiritual awakening. She realizes that her faith is not a cage, but a set of principles designed to ensure justice. And sometimes, justice looks like a final decree and a new beginning. But as we conclude this part of our masterclass, we have to look at the big picture. We have dismantled the legal, financial, and spiritual hurdles. We have seen how the community is changing and how the law is adapting. But there is one final question that haunts everyone who has ever walked this path. After the papers are signed, after the move is over, and after the mosque has stopped whispering, what is left? What does the future of the American Muslim family actually look like in 2030 and beyond? In the final part of this series, we are going to look at the new normal. We will examine the long-term impact of this cultural shift on the next generation, the rise of the intentional family, and how the collapse of the traditional marriage model might actually be the very thing that saves the faith in America. This is the conclusion you cannot afford to miss. The collapse of the traditional marriage model might actually be the very thing that saves the faith in America. This is the conclusion you cannot afford to miss. In 2026, we are witnessing the birth of the intentional family, a radical departure from the inherited structures of the past. For decades, the American Muslim family was often held together by the gravity of social pressure and the fear of communal exile. But as those external forces weaken, a more resilient internal bond is taking its place. We are moving toward a reality where marriage is no longer an obligatory survival pact, but a conscious, daily choice. This shift is not just about the end of unions, it is about the elevation of the quality of those unions. To see the new normal in action, we must look at the lives of people like Omar and Amira in Phoenix, Arizona. It is late 2026, and they have been divorced for 3 years. In a previous decade, their story would have been one of total fragmentation, a bitter split followed by years of silence and used children as messengers. But Omar and Amira represent a case study in high-functioning co-parenting. They utilize a suite of 2026 tech solutions, from shared encrypted parenting calendars to automated financial apps that manage child-related expenses without the need for a single text message that could trigger old wounds. They have moved past the emotional volatility of the divorce and into what sociologists call the business model of family. Step by step, the intentional family follows a specific 2026 blueprint. First, there is the decentralization of the conflict. Instead of litigating every disagreement in a courtroom, they use professional mediators who specialize in cultural bridging. Second, they have established a nesting arrangement for their 2 sons. Rather than the children moving between 2 different worlds every week, the children stay in the family home, and Omar and Amira rotate in and out. This model, which was rare in 2020, has become a standard recommendation in 2026 for families with the financial means to support it. It prioritizes the stability of the next generation over the convenience of the adults. Historical trends suggest that children raised in these stable, high-functioning divorced households show levels of emotional maturity and religious engagement that often surpass those in high-conflict, intact marriages. This brings us to the most critical data point of 2026, the impact on Gen Alpha. These are the children of the cultural shift. They are growing up in a community where divorce is a known reality, not a hidden shame. Because the stigma has been reduced, these children are not carrying the burden of their parents' secrets. In 2026, we are seeing a fascinating trend where these young people view faith not as a set of rigid social constraints that protect a marriage at all costs, but as a source of personal ethics and resilience. They are staying connected to the mosque because the mosque has become a place that supports their complicated reality, rather than a place that judges their parents' status. Imagine if the Mosque of 2030 becomes a true community hub. We are already seeing the early stages of this evolution in 2026 in cities like Dallas and Chicago. These institutions are no longer just prayer spaces. They are integrated service centers. They host post-divorce support groups that look more like professional networking events than pity parties. They have on-site legal clinics that help young couples draft the pre-nikah contracts we discussed in earlier parts, ensuring that the next generation never falls into the Mar trap. This professionalization is the savior of the institution. By acknowledging the reality of divorce, the mosque becomes relevant to the actual lives of its congregants. Furthermore, we must look at the economic empowerment of the single-parent household. In 2026, the rise of the Muslim Professional Network for Women has turned the poverty trap of the divorcee into a historical anomaly for the middle class. We are seeing case studies of women who, after their divorce, have scaled their own businesses or reached executive levels in healthcare and tech. Their financial independence is the bedrock of the new normal. When a woman is not economically dependent on a marriage, her participation in that marriage becomes an act of genuine will. This creates a higher standard for men as well. In 2026, the traditional husband can no longer rely on his role as a provider to excuse emotional absence or domestic negligence. He must be a partner in every sense of the word, or he faces the reality that his wife has the means and the social support to exit. This leads to the pre-nikah revolution of late 2026. We are seeing a massive spike in parents who are demanding rigorous multi-month premarital counseling for their children before a wedding is even considered. This counseling includes financial disclosures, psychological testing, and deep dives into conflict resolution styles. It is a proactive defense against the divorce rates of the past. Historical trends show that couples who undergo this level of scrutiny in 2026 have a significantly higher rate of long-term satisfaction. They aren't just getting married. They are building a foundation that can withstand the cultural pressures of American life. But what about the faith itself? This is where the collapse of the old model proves to be a blessing. When you remove the coercion, the spiritual practice becomes more authentic. In 2026, we are seeing a movement of what scholars call the internalizing of Islam. People are no longer practicing just to please their parents or avoid community gossip. They are practicing because they have found a personal, spiritual anchor that helps them navigate the complexities of modern life, including the pain of a divorce. The faith is being stripped of its cultural baggage and returned to its core principles of justice, mercy, and individual accountability. Consider the potential outcomes for the American Muslim identity by 2030. We are looking at a community that is more transparent, more professional, and more emotionally intelligent than any that came before it. The divorce crisis of the early 2020s was the fire that refined the gold. It forced the community to confront its shadows, domestic violence, spiritual abuse, and economic inequality. In 2026, the lessons learned from those struggles are being baked into the very fabric of how new families are formed. As we conclude this deep dive masterclass, we have to recognize that the story of divorce in Islam in the USA is not a tragedy. It is a story of evolution. It is the story of a minority community figuring out how to thrive in a secular, litigious, and individualistic society without losing its soul. It is the story of men and women who were brave enough to say that a broken image is better than a broken spirit. The shift from the traditional to the intentional is the great work of our time. But even as we reach this new normal, a new question is already rising on the horizon. As the community becomes more professionalized and integrated into the American legal and social fabric, will it lose the very thing that made it distinct? In our next series, we will explore the great integration of 2030, how the second and third generations are redefining what it means to be an American while maintaining a global religious identity. We will look at the rise of Muslim political power, the evolution of the American halal economy, and the final merger of Eastern values and Western reality. The journey of the American Muslim family is far from over. It is simply entering its most sophisticated chapter yet. Stay with us as we continue to track the seismic shifts of our generation.